Allison Schaberg here, Consolidated Planning Group. We are excited to be with the Monarch School today, and we are excited to have Boyd Handley with us today. He's going to be talking to us about guardianship and or alternatives to guardianship. This is a common theme. We get a lot of questions about this every single week, whether or not when to consider guardianship versus some of the alternatives that Boyd's going to talk about, what have you, and is there a such thing as partial? So if you've got kids that are transitioning and you're kind of moving through some of these steps, this is going to be a great presentation for you to hear today. Just so you know, from a housekeeping perspective, your cameras are muted, your microphones are muted, so we can't see you or we can't hear you, but we do know you're there and we're glad you're here today with us. Today's meeting is being recorded. You will get an email with the PDF of the slides as well as the link to the video. Basically, all of our presentations that we have are out on a YouTube channel for Consolidated Planning Group. So you can go back and look at past videos as well. We really try to put out on a weekly basis a number of transition topics as it relates to special needs families. Consolidated Planning Group is a holistic special needs financial planning firm. We really work with families in kind of determining the best steps as we're planning and kind of coming up with future care plans, cost estimates, et cetera, and maximizing Social Security benefits for a child that qualifies for childhood disability benefits under a parent's record. So we're really happy to be here with you today. Again, we're happy that you're here. I'm going to turn everything over to Boyd. And Boyd, as always, it's a pleasure being back with you. I know it's probably like homecoming coming back to Monarch. Didn't your daughter attend Monarch at one point?
Yeah, many years ago, and a great bunch of people there, and she thoroughly enjoyed her time and was really able to blossom by the help of the Monarch staff. So I have fond memories of Monarch. So
I love what Monarch is doing in our area. It's a big difference. So we're happy to be partnering with them today. So having said that, I'm going to turn everything over to you, Boyd. We do want to hear your questions today. So if you have questions, don't be shy. Put them in the chat box. I'm going to read those questions out to Boyd. We're going to get to as many as possible, and we'll also bridge some questions that we know that come up time and time again. So we're glad you're here.
Thank you, Allison. Looking forward to it, and thank everyone for taking their time out of lunch to do this. Just unfortunately, I have to tell you this: this presentation does not create a client-attorney relationship, and also I like to say that this is general information. Every person's situation is unique, so please don't take this verbatim, and go back to your attorney if you have another attorney and say, Mr. Handley said this, because everything's very different. Next slide. I have a special needs toolkit, which I talk about a lot, and we're going to talk about the left-hand portion of that, guardianship and the alternatives to guardianship. Next slide. As I mentioned, we have a special needs toolkit, which is really something that all parents should look at and be aware of. And as mentioned before, we're going to go down to the middle part and talk about alternatives to guardianship, which is the power of attorney, medical power of attorney, HIPAA and decision-making agreements, and the guardianship itself. Next slide. Unfortunately, in Texas, or fortunate, depends on how you look at it, when our kids turn 18, they're adults, whether they're able to function as adult in this society or not. And what happens is that unless we have the alternatives to guardianship documents signed by our loved one or go through a guardianship, we cannot help them like we helped them prior to turning age 18. So based on the legal situation in Texas, we have to make some decisions once they turn 18 or prior to turning 18. Next slide. Normally when someone comes into my office and says, I need guardianship for my child, I really go through these steps. They're put out by the American Bar Association. I always presume until I get all the facts that a guardianship is probably not needed. And then I go through and ask the family a lot of these questions. I won't go through all of them, but they're very helpful in determining whether the child needs guardianship or whether we can help the parents in doing something as an alternative to guardianship. Next slide. Guardianship in Texas took some turns back in 2015. We had the legislature passed two bills, one, the alternatives to guardianship. And although we as lawyers and parents of kids that we have guardianship, we always looked at the alternatives to guardianship, but now it's law that the attorneys have to really look at the alternatives to guardianship, and especially after the individuals have turned 18. A lot of this has to do with if we're getting guardianship of elderly people, we really look to see if they may have capacity to sign a power of attorney, a medical power of attorney, instead of getting guardianship of them. The other major deal that was done is what we call supported decision-making agreements, and we're going to go over those quite a bit in this presentation. Next slide. There's four types of guardianships in Texas. There's full and limited, and then there's guardianship of the person and the estate, and temporary guardianships. An example of temporary guardianship, just say if both parents died in an accident and they have the alternative guardian as someone maybe out of the country, we can do a temporary guardianship for that person. And then while the guardian that was named in the will comes into the country and gets full guardianship. Normally when our kids are turning 18, we get guardianship of the person. That's basically giving the parents the ability to do what they were doing prior to age 18. And the other one is guardianship of the estate. That's normally done if you have an adult that's been in a catastrophic accident and is incapacitated, or you have an older person that has assets, land, property, and we get guardianship of the estate. And then we can combine these two. The main difference with guardianship of the estate, you have to file reports every year and actually tell the court how you're spending the estate of that person. Next slide.
So, Boyd, in the example of guardianship of the estate, in the example that a family already has a funded third-party special needs trust, let's say, for instance, grandma or grandpa passed away and left a couple $1 million to the special needs individuals trust, right? In that example, if there's already a trust with that kind of money in it, is it reasonable for them to have the guardianship of the estate as well?
No, because that individual cannot get to the funds in a trust, in a special needs trust, so it's not considered the estate. So if you've got a trust set up, then that's not going to cause you to have guardianship of the estate.
Got it.
Yeah. One thing I might mention, I've had a number of clients that have had a parent pass away and left a life insurance policy to a minor. And unfortunately, when you call the life insurance company up, they're going to give you a couple of answers in order for you to get that money for the minor child. First, they're going to tell you to get guardianship of the estate through probate court, and then you can have access to the minor's money. Or they're going to ask you to put that money into a underage minor account, which the individual can get the money out at age 18 or 21, or just wait until they turn 18. So there's different uses of guardianship of the estate. That's just one that we try to tell our parents, don't give life insurance policies to minor, give it to a trust. And then if you die without a will and your will goes to a minor, then there's some issues there in the state of Texas. Next slide.
Boyd, I just want to comment on this. And if you guys have visited any of our webinars before, I think that this is a topic that might come up every single webinar about accidentally, leaving assets in the wrong buckets to your special needs child. And so I just wanted to reiterate just what you said, because from from the financial planning, the special needs financial planning side, what we see very often is that, and if you've done this, okay, you're not alone. I mean, probably a high percentage of who's on our webinar today have done this before, where you have your life insurance and you have named your spouse as beneficiary. If something happens to you, your spouse is the beneficiary, and then you've listed a contingent beneficiary or a secondary beneficiary. Basically, if you die and your spouse is already dead and gone, then that's easy. We're going to divide the money amongst our children. So if you've done that, you're not alone. A lot of people do that, but in this example, it's wrong. It's just wrong because in that example, it can cause your child to be ineligible for SSI and Medicaid, or to lose SSI and Medicaid. And then there's definitely the right bucket. So we have whole presentations on this, but we just, if you're taking notes, I think it's important to just jot down. You're going to want to look at life insurance, 401ks, 403bs, old pension plans, and you also might want to check with your affluent parents or other family members that might be considering leaving money to your special needs child, because it all matters in that regard.
Yeah, that's a good comment. Of course, with us, we've got my wife is the first beneficiary, and then my daughter's special needs trust is the second. I'm actually doing a case right now where we have a father that died and left his special needs child a third of the inheritance. And we're in the process of either changing the will, allowing the executor to put that money into a trust for the child, or doing what we call a 1301 special needs management trust within the probate, in order to get that money so it won't count against the Social Security. So SSI. So that, you really need to understand some of these situations, and it's a lot easier to fix them now than to have to fix them in probate court. Next slide.
And that's exactly what I was going to say, is it can be fixed. So if somebody dies and messed this up, or a family member left money to your loved one and you had no idea that it was coming, it can be fixed. It's just time consuming, and it costs money in the legal, in the legal side of the house.
Yep. All right. We've talked about a lot of times people think guardianships are full, or they can either be full or partial, and they're also not permanent. A lot of people think they're permanent, but you can always go back to court. A lot of situations, our kids turn 18 and maybe they're not mature enough right now to make decisions, or still learning how to deal with their disabilities. So you can take a number of the rights away from these kids, and then maybe in 5 or 6 years, you can always go back to court and give them some rights back as they mature and stuff. I have a great, you can read this, but I always like to tell it, back when a lot of the judges were changed in Harrison, Fort Bend County, I visited the courtrooms to see how the new judges would, conduct their hearings. And I had this one young man, we were sitting out front, he was nonverbal, he was using a machine to talk, and we were talking back and forth. And lo and behold, we went into court and he was having his rights given back to him. He had gone to HCC and got a computer degree, and it was fantastic. First one I've ever been, part of, or at least sitting in the audience. And not a teary-eyed was there, and it was just, we all clapped inside the courtroom when he was giving his rights back to him. So it's a great feeling. And I, just want to tell parents that, it's always very hard to make that decision. I know when we did with our daughter, we knew she was going to have guardianship, but it's a very emotional time. And, you think yourself, why am I taking these rights away from our loved one? But you're really protecting them from the outside world until they're ready to deal with that. And I know back when we did my daughter, she's 27 now, but, we were in the courtroom, and it was real funny that we were talking and the judge was asking my daughter some questions, and my daughter was answering the questions, and the judge was looking at us going, why is she in here? And then, of course, as the questions got tougher, she nodded to me and said she understood. But, it was very emotional. And right now with COVID and all, we're having Zoom meetings, so you can be in the comfort of your home. So it's not quite as hard on the parents and everyone, but we still have to make that decision. Next slide.
Boyd, I want to just talk about, because this comes up every single time, let's talk about IQ scores and kind of, if you're thinking about that, to have guardianship, not to have guardianship, what is that threshold and capacity of being able to sign and understand what they're signing?
Yeah, let me go over that in a few minutes when I go over the powers of attorneys, because I like to tell the difference between that and the supported decision-making agreements, okay?
Perfect.
Don't let me forget that. Next slide. As I mentioned, we have the rights that are taken away from our young ones. The bold rights or the main rights that are in the code that are taken away, and then we always throw what I call some of these soft rights in to take away. But you can pick and choose those. A lot of my clients are still able to vote in public elections, and then we take away the other rights. So look at those, and you know, you can pick and choose if you feel that your loved one can make some decisions for him or her. Next slide. Guardianship of the person, that basically is doing everything you were doing prior to your child turning 18. Unfortunately, once they turn 18, we can't call the doctors up and ask for the records. We can't make medical decisions for them. You can have someone take advantage of them, such as signing a contract to buy a car and things of that nature. It's almost like our young ones and an elderly person when someone takes advantage of the elderly persons. But basically, as I mentioned, the guardianship person is really doing everything you did prior to your child turning 18. It's not as complicated as guardianship of the estate. The only thing with guardianship of a person is that you have to do annual reports to the court each year, and then renew your guardianship letters. I believe currently the filed annual report is $12 for Harris and Fort Bend County, maybe a little different from Montgomery and Waller. And then that's $2 a piece for the guardianship letters each year. So basically, it's going to cost you about $22, $24 to renew each year for your guardianship papers. Next slide. Guardianship of the estate, much different. You're dealing with the wards. Unfortunately, that's what I call the court calls our loved ones. Financial well-being, you're looking after the estate. In most cases, you have to have a bond for the amount of the estate for the person that's looking after the guardianship of the estate. With that, you always have to file a major report within 30 days of filing that or getting your guardianship papers, and then a lot of other financial work that you have to do each year. In most cases, guardianship of the estate, you have to have an attorney on retainer to help you file those reports each year. Next. What are the guardianship steps? Well, we can file guardianships 180 days prior to the 18th birthday. I normally tell my clients to give me a call in about 8 months before they turn 18. I can give them the steps of guardianship. We have to have a physician certificate signed by MD, which can be a psychiatrist or your physician. And I normally tell with the COVID, it may take a couple of months to get an appointment for that MD to see your child. Once we file the application, we're going to have a citation served by a constable. My daughter loved it because the constable came up and knocked on our door and gave her a piece of paper. Normally, that's pretty discerning with families when you have someone knock on your door. And but I always tell parents it's coming about, and one thing you have to deal with. Nowadays, the guardians also have to take a online training course by the JBCC, which is the judicial branch that looks after guardianships in Austin. A couple of years ago, you had to actually take a test. I actually took that. I was grandfathered, but I couldn't actually tell my clients they have to take one when I didn't do it. Nowadays, it's really no questions involved. It's just a 30-minute presentation, and we have to do that. All the courts appoint an attorney ad litem for your loved one. That particular person will visit with you and your loved one, mostly by Zoom. About 50% of my clients are being visited in-house now, so that's opening up a little bit. If your loved one has any older siblings or a biological parent or group home administrator, we have to serve those individuals with notices or waiver letters. And then if you're in a statutory probate court, which the surrounding counties, Harris and Montgomery County, are statutory probate courts, and the judge will also appoint a court investigator to come out and visit you. So those are the main steps. I'll normally like for my clients to get close to the 180 days when we file, because we can get all the paperwork done, get the attorney ad litem appointed and visiting the families, and then try to get the hearing as close to or as close after the 18th birthday as we can. Next slide. Here's just the JBC training course. It's really a good course. It really goes over all the different steps that you need to do with guardianship. And it's almost probably better to take it before you file guardianship, because it also goes with the alternatives to guardianship. But just wanted to give you the different things that you'll be looking at if you do decide to get guardianship for your loved one. Next slide.
And this, just so people want to see, this is through the state of Texas. It's not per county. Where could they go to get this course if they were interested in taking this course?
Normally what I do with my clients is I register them with the JBCC once we file for guardianship, because there's a number of questions that I would have to answer in that. So I do that for my clients. I can give that information to the clients and they can do themselves. They can actually just go Google JBCC and Google, and it'll come up with that. Mm-hmm. I've had one or two clients that have taken the course before they registered, which is fine. I normally like to do that all together with my clients. This is the first 2 pages of the physician certificate. I did it this size so you couldn't tell what was in it, but basically the first page goes over the physical or mental disabilities of the child. The second page, all those little boxes, or how the disability affects their everyday living. And then on page 3, there's a box for intellectual disability to be done. And then fourth page is just some questions to be answered. One thing I might mention is that on the first page, if you ever do go, I'll talk to a client later about this, but on the first page, it has one question that a lot of the courts really need to have answered. It says, before the examination, I informed the proposed ward that communications with me would not be privileged. That's kind of like a Miranda right. And it's always very important to have that checked yes by your physician. There's some courts that will not even take the physician certificate if it's marked no. And some courts, we can get the judge to approve that if it's not said no. So that's really important on that. The other thing I like to mention on this is on the page 3, where it has the intellectual disability questions and has the scores on that. One thing about it, normally if we have an MD to do this, he does not do the intellectual disability test. And so there is a box there that the physicians can check saying, I looked at another report. So he can actually look at a report that your psychiatrist or your school might have done on your child and mark that up for you. Next slide. Who can qualify for a guardian? As long as the guardian's over 18, that will work. You really can't have a criminal history, such as a felony. I've had a number of I've had one parent that had some felony charges back 20 years ago, and they have now lived a better life now and hadn't had any problems since they were young. And so we were able to get letters from the people that he or she worked for, along with some other letters, and was able to get the judge to agree to disregard the previous criminal history. I've also had a client, I was actually attorney ad litem on this one, but where he had a DWI that he didn't tell his attorney. And we were in front of the judge, and the judge mentioned that, sir, didn't you have a DWI 2 years ago? And he said, yes. And the judge would not let him be a guardian. They were going to be co-guardians. And so the judge did tell that person that if he was, without any DWIs in the next 2 years, to come back to court, and the judge would consider letting him be co-guardian. So it's really important, that if you do have any kind of criminal history, let the attorney know that's working on your guardianship to do that. I want to mention that family members, of course, can be the husband and wife. Well, the biological parents can be co-guardians. You can have one biological parent and a step parent be co-guardians if the other biological parent signs a waiver and agrees to the step parent being a co-guardian. Sometimes that's very hard to get. Or if the other step parent, one of the biological parents is deceased, then the biological parent and a step parent can be co-guardians. But that's the only time you can have co-guardians in a guardianship in Texas.
So since divorce does happen, and it does happen much in greater numbers in special needs families, in the event that you are in a divorce situation and the other parent is adamantly against guardianship, what as the other parent, what options do I have, and if it's in the best interest of the child, does that matter? And that's the first question. And then the other question is in this divorce situation, let's just say one parent has primary custody and that parent would apply for guardianship, but the other parent is an active parent and they want to be co-guardians, but the other parent doesn't want that. How does that work? So I know those are two very different questions, but I think these things come up all the time.
Yeah, let me just go to different scenarios. I've done quite a few where you had parents that have been divorced. They're still getting along very well with each other, so they're co-guardians. That will work. If you've got a parent that's divorced, you can't find the other biological parent. All we would have to do is have that parent served by a constable at the last known address, and then the remaining biological parent can get full guardianship off that child. The other situation, if you've got two parents that are divorced, totally disagree with each other, one parent can file for guardianship. The other parent would be served with a waiver, and then that parent would have to file a contested guardianship in court, and then we would go to court and in most cases go to arbitration and see if we can come up with an agreement, and then at the end of the day the judge will make a decision. The one thing I will say, we've got great judges in the surrounding counties, Waller, Montgomery, Fort Bend, and Harris County that I work in, and they do look at the best, what's beneficial for the child, and they're going to put that above all issues that the parents may come up with. So, but those are the situations that you would go through with that. Mm-hmm. Next slide. Alternatives to guardianship. There's quite a few that are in the code. These are most of them. We're going to talk about durable and medical power of attorney today, along with supported decision-making agreements. One thing I will say, if you've got a grandparent, if you got a parent that's elderly and they do not shouldn't be driving. I always like to say that there are case laws and the retest request. You can request DPS to give your parent another driving test, and they won't know who did that. So instead of just taking the keys away from them. So that's something to keep you knowledge of. Next slide. Medical and power of attorney and medical power of attorney. Why do we need those? Well, once our child turns 18, we can't do any banking or financial work with them or any kind of contractual work. And then also with the doctors, you can't call a doctor up and whatnot. Unfortunately, with the power of attorney and medical power of attorneys, our loved ones have to have the mental capacity to understand what they're signing and be able to do that. I have a cutoff of 70 IQ in my office before if they're below 70, then I won't sign a power of attorney, a medical power of attorney notarize one for a client's child that's just turned 18 or maybe older. I know there's some attorneys that will go to 65, but I just have a cutoff because I've been around it long enough to understand. Now, if your kid's above 70 and you need a power of attorney, medical power of attorney, and they have disabilities, then I will talk to them and ask them questions in another room from mom and dad. When I first started doing this, I had mom and dad in the same room, and the young man looked to the left, looked to the right to ask mom, should I say yes or no to those questions? So I just have that cutoff. That's the cutoff that SSI uses for mental disability. So that's what I use. A lot of it's from a liability standpoint. So, but also do a lot of power of attorneys and medical power of attorneys for kids that don't have disabilities. If your child is going off to college, then you really need to have at minimum, a medical power of attorney and for them in case they get in an accident and you need to call the hospital about them. And normally I tell parents to go ahead and get a power of attorney also. And there's also the HIPAA agreement, which is something you need to have in order to obtain medical records for your loved ones. So I normally, this happens a lot with our parents as they get older in age. They may become incapacitated or get dementia. You really need to have the power of attorney, medical power of attorney, HIPAA on your parents. My parents are very good. I had it on both of those. So I was able to help. And a lot of times our parents do not want us in their business. So we can actually put in that these documents are not effective until you become incapacitated. And we can also say until a doctor, tells you that you're incapacitated. Next slide.
I just want to echo here too that this is important for you too. So whether you're 40 or 50 years old and you're feeling pretty great, this is just important for you to visit this too. If you and your spouse become incapacitated, that you have this. In the last few years, I've had a few, actually two different, clients that had a family member that had a massive middle brain stroke but did not die, right? And so these documents are critically important in that incapacitation state. It's so important. And also, and you mentioned this, Boyd, but again, so, whether this is the direction you're going in lieu of guardianship, power of attorney, healthcare power of attorney with your special needs child, your child that you're sending off to college, this is so super important. Any accidents that could happen, on the way to and from college, those types of things. But also on the college level, I just wanted to also say that the FERPA, it's the FERPA document. The schools have this FERPA document, and basically they're not going to talk to you unless that FERPA is signed. And so you might want to add that to your list as well. But we see a lot of issues with this not happening or not being in place. So make the decision now while you are of sound mind and body, your parents are of sound mind and body, because it gets real difficult if it's not there.
Yeah, I also want to mention with that, my mother-in-law recently was in a wreck and was taken to the hospital, and my wife fortunately had the medical power of attorney in her phone, and she was able to send that to the doctor. And of course, a lot of the hospitals are not allowing you in, so she was able to talk to the doctor from the parking lot about what was going on with her mom. So extremely important. In my situation, I keep my daughter's guardianship letters in my phone in case I need them. And my wife does that also. And just from personal experience, very important to do that. Supported decision-making agreements, a great document, but I think a lot of people are misinformed about how to use them. They're very good, and if you've got a high-functioning child, that will allow you to go into meetings with them, whether it's financial, school, or whatever, and explain to them what the meeting's about to your loved one. In a lot of cases, we know how to communicate with our loved ones where they may not understand what's being said to them in those meetings. And that's what this document does. I do not do these. You can get them online. And they're also good if you've got a situation where you may not can afford the guardianship. Of course, we have a whole section of pro bono attorneys in the Houston Bar Association. There's disability rights if you can qualify for their income limits, and they can do guardianships for you. But if you haven't gotten to that point yet, or haven't saved up, if you're over that money amount, this can be done. And the main thing about this, it doesn't have the capacity wording that the medical power of attorney and power of attorney does. So there's that gray area where your child can probably sign one of those, and you can get by with it. So it's very beneficial in that aspect. Next slide. Again, I mentioned this, is that the level of capacity is not mentioned on this document. Next slide. All right, what this does and what it doesn't do. You cannot make decisions with this document. Basically, you can assist your young one that's now an adult, and what's going on, how to make a decision. But at the end of the day, your loved one has to sign on the dotted line or tell the group that he or she is in front of what decision she will make. So that's the main thing I like to tell everyone, that these documents will get you into a meeting with your loved one and allow you to explain the situation to your loved one, but your loved one has to make that decision at the end of the day. Next slide. All right, we've talked about.
Boyd, can I just ask a question here on the
Sure.
supported decision making? Like, just, for lack of a better word, let's play devil's advocate for a moment. Like, why do I need a supported decision making agreement? Like, why do I need this paper saying that I can go into a meeting with somebody or can assist my family member in making decisions? As a parent, isn't that what I do? I mean, I guess what I'm asking is, like, how valid is this supported decision-making agreement, or how, like, maybe it's important if you've got a child that's staying in school until 22 or something like that. Like, just, can you talk about that just for a second? Not all states even have this, right?
Yeah, no, they don't. Give you an example. Once your child turns 18, the school is going to make your child sign a document saying that you can attend the ARG meeting. Okay. Well, you know very well that your child does not have the capacity to understand what they're signing. Okay. So I would probably get a supported decision-making agreement and have my child sign that, where I could attend ARG meetings or attend doctor's meetings with them if you can't afford a guardianship. And that's where it comes in. I would be very hesitant if my child did not have the capacity to sign a medical power of attorney and power of attorney, for them to sign one, because there could be some liability issues with you as a parent if a third party comes in and says, or an older sibling comes in and says that mom and dad is not taking care of my brother and sister, or if something happens. So that's the main deal with the this agreement, is that it's kind of a stop in between a power of attorney and guardianship that a parent can use. That's really the way I look at it.
We have a question, and does your child need to sign this agreement to have the process completed? If the child does not agree, does the process stop? And well, and I think that that's a twofold question, because we were talking about the supported decision-making agreement, but let's add that to the guardianship side of it as well.
No, that's a good question, and I'm glad it was brought up, because I forgot to say something on guardianships. I've got the thing about power of attorney and medical power of attorney. If your child wakes up one morning and he or she is mad at mom and dad, if she says, you can't have my power of attorney, medical power of attorney to someone, then it goes away. I've got a number of parents that have adopted kids with fetal alcohol syndrome, which is a situation where during gestation the mom was drinking and now a part of the brain is missing, so they have a lot of anger issues. And I really like to counsel parents in that situation. You may have a very high functioning child to a certain degree, but with a lot of violent tendencies and anger issues, and you may want to consider getting a partial guardianship instead of having them sign a medical power of attorney or power of attorney, because again, if they get mad at you, that document goes away. And also least restrict, this decision-making agreements, your child has to sign that. And if they get mad at you one morning, then it goes away. So you really have to understand the limitations of your child once they turn 18 and you don't have guardianships. They control their own destiny. Mom and dad, without these 3 documents, cannot make any decisions for them, cannot talk to anyone, whether it's financial, whether it's medical, without those documents. Just say, for instance, if I've got a credit card, or my wife has a credit card and my name is not on that credit card, and I'm not the primary credit card holder, unless my wife has called the credit card company and given permission for them to talk to me, she would either have to do that, or I would have to have a power of attorney in order to talk to the credit card company. So it's really simple stuff like that. But parents have to realize that once our kids turn 18, they're adults, whether they can function as an adult or not. And we have to have either guardianship or these alternative to guardianship in place to be able to deal with them the way we dealt with them prior to turning 18. And
I just have a quick question here. I've come across some families over the last few months that basically their child's IQ is below 70. They don't have guardianship. They should have guardianship. They've just always done everything for this individual. So maybe the individual is 25, 35 even. I mean, I've seen them older. And maybe when that child turned 18, it just wasn't that big of a thing. It's become more prevalent than it was in the past, or more people are talking about it. So in that example, we've got mom that's 75 or 80 years old. Mom dies. The child's IQ is below 70. There is no guardianship. Does the kid just bump around themselves until somebody steps in and the state says this person needs to be awarded the state? What happens in those scenarios if a person says they're putting it on hold, they haven't done it either on purpose or on accident? What happens?
Yeah, I've had a situation where I've had some parents in the late 80s, and they didn't have any family members that wanted to take care of their 55-year-old son that had mental issues. So they asked the state of Texas, the Harris County Guardianship Association, to take care of that. And I was the guardian ad litem for the young man. And so we went to court and got guardianship. Harris County took over guardianship of that person. I've had another situation where in your example where the parents had died and the man that was 65 was rambling around and town living under bridges and stuff. And a friend of the family's got a attorney to get a medical certificate filed with Harris County requesting a probate proceeding for guardianship of that person. So Harris County went in and did that. So that's really the only thing. The other thing, there are some private guardians that are certified in the state of Texas. There's Brazos Guardianship in Fort Bend County. So there are avenues that the parents can go forward and have a private guardian done, or a friend of the families, or a professional guardian to look after their child down the road. If they've got money, then they can pay those. If they don't have any money, then the Harris County guardianship group can take over. And then, of course, the SSI or Medicaid or Medicare can pay for the facilities that they put them in. The good thing about Harris County, there's a lot of group homes that are not certified. And Harris County, if you're under the Harris County group, they will put your loved one in a certified group home. And that's much better than all of these group homes that are popping up everywhere that have these individuals in it.
I think the key thing is think this through, because we do talk to families on a weekly basis that say it's the end of the line. After me, it's done. There is nobody else. Or we have a loved one that has, like, as you said, mental health issues or aggression issues or things like that. And other family members, as much as you would love for them to step in, they're not going to. So having that backup plan, is it a professional guardianship? A guardian service? Is it where you've partnered with a residential care facility, and that particular residential care facility is willing to take on guardianship upon your death, or what have you? That's a question. If you're considering residential options post high school or whatever, that's a question to ask. And I put it out there frankly, and Boyd has a special needs child. I have two. So when I say this frankly, I'm not meaning it rude, but can my loved one live here and die here? Can they stay here? Can they grow old here? If I die, I'm dead and gone, and can you become the successor guardian? What if there is nobody else? Those are all good questions when you're kind of entertaining some of these options in the future, transition programs or other respite care or other things. And maybe it's not care right now, it's maybe in the future, a long time down the road, into your retirement, to where you have become at a place where you're not capable of caring for your loved one anymore. I have a question here, and it says, if you apply for guardianship in Texas and then you move to another state, do you need to reapply for a new guardianship? Good question.
Yeah, I've just recently had a couple of cases where parents have moved from other states into Texas, and we transfer their guardianship. In Texas, if you transfer a guardianship in, it's basically the same process of applying for a new guardianship. We have to have the records, certified records, transported to the probate court here in Texas. You do not have to have an attorney ad litem appointed to your child, so it's a little bit cheaper, but really it's the same process. I do not know about other states, but if you move out of state, you do have to tell Texas that you're moving out of state, and most likely get a probate attorney to register your guardianship in the state that you're going to. The all other thing in Texas, if you move to another county, you have to transfer your guardianship from Harris to Fort Bend, or vice versa, wherever you're moving in Texas. We moved like 2 miles a couple of years ago across the county line, so we had to move our guardianship from Harris County to Fort Bend, where we are now, and that was very easy. It just took a letter to the probate court. They didn't charge us any money for that, so it may be a small fee, but that is possible, and you do have to do it if you transfer to different counties.
So you answered that question. I was just curious if people were in the process of moving counties and they have a child that's turning 18, should they wait till they get to the new county? But you said it's easy. It's a simple fee. Yours was free. It could be $5, $20 or something, any 5, 10, 20, no big deal is basically what you're saying. So don't necessarily delay the process. If you can start the process 6 months, 6 to 8 months prior to the child turning 18, delaying it because you're going to move counties is not necessarily the right thing to do. Is that correct?
That's correct. Yeah, I had a question the other day from a lady that I know that's moving once her child gets out of high school, special needs, she needs guardianship. And she says, well, we're going to probably move in 6 months anyway. Can I wait until my daughter graduates and we move to the new state? Well, it's up to you. I would, there could be situations from a risk profile where you have a medical issue with your child after they turn 18 before you move to the new state that you can't make a decision on. And it's just really better to go ahead and get guardianship now and pay the price to transfer it to a new state. Because if something comes up, it's not worth taking that chance in those 6 months that you have to work with.
So boys, let's say for a moment, because I've actually seen this quite a bit, let's say for a moment that I live in the state of Texas as mom, and I have a child in a residential treatment facility in Utah, for instance.
Yep.
In that example, I live here, the child basically resides there. Does the guardianship need to be in Utah in that example, wherever the child is at?
Yeah, that's correct. I had one where the parent lived in Houston. Their child was in a facility in Florida. He asked me to do the guardianship. I said, well, unfortunately, I can't. You'd have to get a probate attorney in Florida to do the guardianship. So it has to be where the child lives. I've had a situation where the child lived in Harris County. The parents lived in Fort Bend County. So he was in a group home in Harris County. So we had to do the guardianship in Harris County. So it's where the individual lives.
That's good. And also, in my experience, what I would say too is that you might want to research if you're thinking about a residential facility in another state. You may that might be in your deciding factor on what their laws are and how, often guardianship is granted versus not granted, or if there's some weird snafu in the law that's going to prevent you from having what you need, because that might be a decision on why you might not go to that state for that residential care facility.
Yeah, that's a good point. If you have guardianship in Texas and they move to a group home out of state, you'll have to transfer the guardianship. That's correct.
It could be problematic. It might not be seamless. I definitely have kind of looked into that for some other states as well, and it's definitely not all the same. Just like we were talking about earlier, the supported decision-making thing is a Texas thing. There are some states that have the supported decision-making agreement, but many states don't. Mm-hmm. So that's another thing that is likely not going to be recognized in another state. So, boy, this is really good information, and it's always timely. It's always something that we need to hear. So the takeaways there's full guardianship, there is partial guardianship, there's guardianship of the person, there's guardianship of the estate. There's a lot of different options. The other takeaway is put it on your calendar that you can start having these conversations 8 months in advance. You can start the process 6 months prior to the child turning 18. If you missed it and your child's already over 18, it's still okay. They can still apply. They can still go through the process. The physician's certificate is the main important document, and that's something that you share with people that reach out to you. And that's the document that's going to have to be certified by a physician of basically the need for guardianship. It's not a matter of one parent thinks more so than the other or something like that. It's going to be certified. So those are the main takeaways. And the other thing is if you have a child, I always use the term late to the party. We're not there yet, maturity-wise. Maybe they're ADHD. Maybe they have some of the executive functioning issues. Maybe they're on the autism spectrum. You might need to do this when they turn 18, but it does not have to be forever. They might need some help getting to where they're going. They might, be a little late to the party, but it doesn't mean that they're not coming. So there's options for that as well. So I'm not going to spend a lot of time on this. We're going to kind of close up, and we always aim to be finished on time. These are just some things that should be on your special needs planning radar. We do have webinars on all of these topics. Some of these things that we have talked about, we do have upcoming webinars that will talk about these things as well. So we invite you to our YouTube channel and also our Facebook page. We post upcoming events. So we will send out an email. Usually it comes out monthly of what events we have coming out over the next month that you might, webinars that you might want to attend. So we've got Boyd Handley, the Handley Law Office, his contact information on here. If you are in need of kind of a personal discussion as it relates to, some of the topics today, whether it be guardianship or, special needs trust or some of those things, Boyd's your guy. And so kind of the difference is a lot of times people are confused on what is my role and what is his role. And Boyd and I often work together, but our roles are very different. So Boyd is the legal side, special needs legal. So these are the documents. This is the guardianship. This is the special needs trust. He's handling power of attorney, wills, healthcare power of attorney, those documents that you have to have to make sure everything is in place. And we're the money, we're the funding. So, we're special needs planners. We're certified as Social Security advisors, and we're basically making sure, A, that there's going to be enough money for your loved one for the rest of their life, not just yours. We're going to make sure that you're not going to run out of money over the 25 or 35 years that you might spend in retirement. And we're making sure that all the money's in the right buckets for future funding for the child, and to make sure that they're not going to miss out on or lose qualifications for specific benefits. So that's how we work together. The difference of a special needs planner and a special needs basically planning attorney, those are some of the differences, and we always like to share that. So it has definitely been a pleasure to have you back, Boyd. Thank you for all the information that you provided. Again, thank you for everybody that attended today, and we look forward to working with you in the future. Feel free to reach out. Thanks so much, everyone. Have a great day.
Bye-bye.